Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Today we want to talk about what do you do when you're separated in anticipation of a divorce, but yet you share joint bank accounts, joint credit cards. What's going on? What do you do about that? And underlying the question is an element of risk. In other words, I have a joint bank account. Now we're going to get divorced. What if my ex clears out the account? Let's theoretically presume that half the money is mine. If my ex takes it all, now I got nothing. What do I do? Is that a risk? And the answer is yes, it is. Same with credit cards. What if we have a joint credit card? Am I at risk to be liable? Should my ex all of a sudden decide to run up those cards? Yeah, potentially you are. The bank doesn't care about your divorce. All they know is they have credit cards in both names, both are responsible. So you got to be very careful about this. A lot of times in giving our clients sort of prophylactic advice about things that could occur, we'll tell them, listen, if you have joint accounts, watch out. Your ex could clear them out. If you have joint credit cards, watch out. They may run them up. You may want to contact the bank in advance, separate out those cards, separate out those accounts. Take half the money from the account and put it in your name so that you don't lose your half. These are precautions that someone could take. Now, a lot of times our clients will say, oh no, my husband would never do that, or my wife, she would never, she's not that kind of person. I have to tell you, it's good that you're married to that kind of person, if that's who you have. But at least half the time, those same people will call me 3 days later and say, would you believe it? They took all the money. And I'm thinking, yeah, I would believe it. That's why I warned you to remove it, remember? So in these kind of things, you can never be too cautious. If the money's in the account and it's a joint account, if you take all of it, you're going to have to do some explaining later on down the road. So you might say, well, if they take all of it, then they'll have to do the explaining. So I guess that's good. Well, it's good, but you'll be cash poor right now. On the other hand, it's smarter to take not all of the money, but take half of the money in an account, document it there, and there's no question that some attorney will call up screaming. Now, he or she took half the money out of the account. We'll say, don't worry, here it is. $20,000 here. Took $20,000, left $20,000. Here's our $20,000. It's right here at Chase Bank, and here's the deposit slip. Here's the statement. You can see it. That way, even if they complain to the court about it, you'll say, Your Honor, all we did was preserve the assets. That's the ultimate job of the court anyway. We're helping everybody out. It's great. If you do something overly aggressive, though, and take all the money, expect that you're going to have to answer some difficult questions. Therefore, in an abundance of caution, you should speak to your attorney. But generally speaking, lawyers are going to tell clients, let's protect the marital assets when they're held in joint accounts because they are at risk. If you have any questions about that, reach out. We'll be glad to help you out.